Hello everyone and welcome to the June 2024 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway and I'm an executive partner here at our Troy office. This month I'll be joined by Aaron Swain. He's an associate attorney over at our Grand Rapids office. Aaron and I will be discussing, of course, the case law discussion, and Aaron will lead the trending topics and PIP litigation portion. The case that I'll be discussing is the Michigan Property Casualty Guarantee Association v. Progressive. This is a published opinion from our great Supreme Court that was recently issued June 7th, 2024. And then next up will be Aaron's portion, where he will be discussing fee schedule disputes and DMEs. Now, the Michigan Property Casualty and Guarantee Association v. Progressive case is, like I said, a to be published opinion. For short, it is the MPCGA. But in this case, the Supreme Court held that the one-year back rule of 3145 applies to a PIP action against a lower priority insurer that commenced after a higher priority insurer declared insolvency. Typically, that's what these Michigan Property Casualty Guarantee Association cases deal with. Some insurer declared insolvency at one point, and now a claimant is looking to secure PIP benefits from a insurance company. But here, this decision reverses a published Court of Appeals decision which held that such claims could be brought up to 6 years after an insurer's insolvency, even when that insolvency was declared years after the dates of loss. And as you can see on the insurance side, issues such as this, where a claimant has 6 years, kind of leaves insurers open to litigation for an extended period of time. Typically, we have the one-year back rule, which kind of closes the gap for claims to be made after an accident. But here, prior to this case, a claimant had up to 6 years. Now, this underlying case was brought by the mother of Justin Childers. He was a minor who was severely injured in an August 2011 car accident. The Childers were insured by American Fellowship Mutual Insurance Company, who paid PIP benefits through June 12, 2013, and that's when the company was declared insolvent. At that point, the Childers claim became the responsibility of the Michigan Property and Casualty Guarantee Association, which is not an insurance company, but rather an association of insurers created by the Guarantee Act of NCL 500-7301. Now, the role of the MPCGA is that of an insurer of last resort, which an insured of an insolvent insurer can look to for coverage only if there is no other insurance company to turn to for coverage. Now, the MPCGA tried to evade liability here by arguing that the Childers PIP benefits should be paid by the next insurer in the order of priority, which here was Progressive. Now, Progressive denied coverage in October 2013, and the Childers filed a PIP action against Progressive on November 22nd, 2013. And then the MPCGA later intervened. Now, ultimately, the trial court granted Progressive summary disposition, agreeing with the insurer that it was not in priority, but indicated that plaintiff's claims were timely pursuant to the one-year back rule. Now, the Court of Appeals here reversed, siding with plaintiffs on both issues. Now, regarding the timeliness, the Court of Appeals panel observed that the MPCGA is exempt from the No-Fault Act and the Insurance Code. As such, the one-year back rule would not apply to them. The panel said that the MPCGA hadn't filed under the No-Fault Act, but the Guarantee Act, which provides it with the right to receive a credit on claims owed to an insured from other benefits for up to 6 years. Now, the Court of Appeals panel held that since the No-Fault Act and its one-year back rule did not apply, and the Guarantee Act itself had no limitation period, the 6-year default of limitations was applied, and that 6-year default is typical of cases that are outside of the No-Fault Act. Now, as we all know, the No-Fault Act is 3145, which the one-year back period applies. Now, the Court of Appeals also found that the Childers action arose from the Guarantee Act, since it obligates a claimant to pursue other possible insurers after a primary insurer's insolvency. Now, on June 7, 2024, the Supreme Court issued a unanimous opinion here, reversing the Court of Appeals and dismissing both actions as untimely. Now, the Supreme Court began its analysis of the Childers claim. Here, the Court of Appeals believed that their claim against Progressive arose not of the No-Fault Act, but rather the Guarantee Act. The Court of Appeals specifically relied upon the following sentence taken from MCL 7931, Section 3. The claimant, insured, or self-insured entity shall first exhaust all coverage provided by any policy or the self-insured retention of an excess insurance policy. Now, the Supreme Court's analysis of the timeliness aspect of the MPCGA's claim was more complicated but similar to the Court of Appeals. Unlike the Childers, the MPCGA's right to recover did flow directly from the Guarantee Act. The court referenced two specific rules: the credit provision, which states that if damages or benefits are recoverable by a claimant under an insurance policy other than the policy of the insolvent insurer, the damages or benefits recoverable shall be a credit against the covered claim payable under this chapter. Now, in addition, the MPCGA's action was also premised on the assignment provision, which I won't go into this entire thing, but their action was also an assignment. Now, under the Court of Appeals holding, an insurer could conceivably be required to litigate whether it was a lower priority insurer and ultimately be held responsible for paying PIP benefits many decades after an accident occurred. And see, that's the big issue here. These claims could be held open for years and years and years, as of this one, which was a 2011 accident, and did not come to Progressive until 2013. Now, ultimately, the court's decision expands the statute of limitations and eliminates the possibility that insurers will be made to litigate stale claims after competitors' insolvency, but these benefits to insurers come without curtailing an insured's ability to recover. Because of that, because there's no clear losers, all 7 justices agreed with this. And thus, we have new precedent for situations such as these. And next up, we have trending topics in PIP litigation, and I will be joined again by Aaron Swain.
Amber, thanks for having me on. Again, my name is Aaron Swain, and I'm an associate here at Seacrest Wardle. I'm located in the Grand Rapids office. Our firm handles cases statewide, and today I want to talk about trending topics in PIP litigation. Specifically, I want to talk about fee schedule disputes and how they relate to durable medical equipment, which is also known as DME. Now, for starters, I think it's important to have a little bit of background on the statute and the changes to the No-Fault Act. As I'm sure we're all aware at this point, there were significant changes to the No-Fault Act that took place in 2019. Several amendments were made. One of those, most notably, was the introduction of what's called the fee schedule. And the fee schedule was a revision to the statute MCL 500.3157. And what that does is that pertains to the charges that doctors, healthcare providers, clinics, hospitals, so on and so forth, that's set in the statutory language can charge for specific training or services for a person's rehabilitative occupational training. Now, specifically, that statutory language that's been revised says in the statute under subsection 1, a, quote, physician, hospital, clinic, or other person that lawfully renders treatment to an injured person for an accidental bodily injury covered by personal protection insurance, or a person that provides rehabilitative occupational training following the injury, and here's the important part, may charge a reasonable amount for the treatment or training. And then the second important part of that statute is the next sentence, which says, the charge must not exceed the amount the person customarily charges for like treatment or training in cases that do not involve insurance. And again, that's found at subsection 1 of MCL 500.3157. So what we want to get into with this conversation is how this statute works, how this statute is applied in real life, and the difference that you see depending on when certain DME was prescribed, when providers may or may not have reincorporated, because we'll get into that later. But, central to this analysis, we need to look at, there's a seminal case called Spectrum Health Hospitals versus Farm Bureau Mutual Insurance Company of Michigan. And that's found at 333 Mich. App 457. This opinion came out in 2020. So the general facts of this case are that on August 22nd, 2016, the claimant was a passenger in a motor vehicle that was involved in an accident. What happened was the motor vehicle hit a tree, and as a result, the claimant sustained significant injuries. As a result of those injuries, the claimant sought treatment at Spectrum Health Hospitals, and ultimately that treatment resulted in medical costs of about $225,279. What happened was Farm Bureau actually only paid a portion of that expense. They paid about 80% of the bills, and in Farm Bureau's defense, they said that they paid that amount because it was unreasonable. This went to litigation, and in the course of discovery, Farm Bureau sent out discovery requests that we would often see in our cases today. Those discovery requests included, annual charges or annual increases in charges from Spectrum Health hospitals, the amount that Spectrum Health hospitals charged for an uninsured, and whether that was the same as no fault, and as well as the Priority Health and Blue Cross Blue Shield rates that Spectrum Health charged. Now, Farm Bureau argued that reasonableness at the time, reasonableness was not defined by the statute, and their argument went on to say that because it was not defined, in the absence of that definition, courts should look at the open market and the cost to charge ratio in order to determine what is a reasonable charge by a provider. Spectrum countered that argument by arguing that the focus of the statute, MCL 500.3157, is on the charges themselves rather than the payments. So instead of looking at what companies would pay, it's what providers are charging. Now, fast forward, this case went up to the Court of Appeals, and the Court of Appeals ultimately held that the analysis is a two-part analysis, that reasonable charges and customary charges are not one and the same. What happened is essentially, in regards to reasonableness, the Court of Appeals held that evidence regarding third-party payments may be relevant and admissible to assess reasonableness, but it's not dispositive. And essentially what this means is that the market value of a provider's charges, the market rate, I should say, is relevant. It's absolutely relevant, and it's admissible. However, it's not the end-all be-all. So there needs to be a deep dive into the investigation, and we'll get into that later. Now, before we get into what is a customary charge, it's important to go back to the statutory language, because under subsection 2 of 3157, there are percentages that are payable to providers, but that depends on when the treatment or training was rendered. So, for example, subsection 2A is that the treatment or training rendered after July 1st, 2021 and before July 2nd, 2022, those rates cannot exceed 200% of the amount payable under Medicare. If you go on to subsection B, that's treatment or training between July 1st, 2022 and before July 2nd, 2023 cannot exceed a rate of 195% amount payable to Medicare. And then what we're starting to see more and more as time goes on is the application of subsection 2C. And 2C is that any treatment or training rendered after July 1st of 2023 cannot exceed 190% amount payable under Medicare. Now, the thing is, though, is that there is treatment that's not covered under Medicare, and therefore treatment that's not covered necessarily under those statutory percentages of 200% and so on and so forth. And that is found later in the statute. So in subsection 7 of 3157, the statute reads that if Medicare does not provide an amount payable, the applicable following percentage of the amount payable for the treatment or training under the person's charge description master in effect on January 1st, 2019, so that's important, or if the person did not have a charge description master on that date, then the following percentage of the average amount the person charged for the treatment on January 1st, 2019. And we go on to have some other percentages, but what that means is charge description masters are lists essentially of charged rates by providers. It's very, very, very seldom that we see these actually produced in discovery, or providers may not just have them. And so the key is if there's a charge description master that was in effect, or if the DME was prescribed before January 1st, 2019, then you have those rates of 55%, 54%, or 52.5%. And what that is that you reprice to that percentage. But if you don't have that charge description master and or the DME was prescribed after January 1st, 2019, then that's where the problem arises. And that's what we've been seeing is some of these providers have actually reincorporated and alleged that they're new entities and that they don't have a charge description master, and therefore their charges should be viewed as reasonable and customary rather than hard defined concrete percentages. Again, those percentages are 55%, 54%, or 52.5%. But as I said, DME, it becomes difficult there because there's no easy formula for DME repricing. It's case specific, and insurers, attorneys, and adjusters alike need to look at the efficacy of the DME as well as the actual pricing that was used, and there need to be deep dives into these cases on a fact by fact pattern. As I said, if there is a charge description master, we can reprice it. If there's no charge description master, it's reasonable and customary. And as I said, as the case of Spectrum Health Hospitals versus Farm Bureau said, when it comes to the reasonableness, you can look at the market rates because that is not dispositive, but it is admissible and it is relevant. So some examples real quick before we get into the next part of the analysis, which is the customary aspect. We want to look at some examples of DME. So things that we see commonly are things such as shockwave therapy, nervomatrix, which you'll also see it by the name of TPII, trigger point impedance imaging, onlux, cold compresses, hot cold packs, cervical pillows, that sort of stuff. But the problem becomes what is customary, because there's case law out there that indicates it's essentially, you look at situations where there's no insurance whatsoever, not even Blue Cross Blue Care, Priority Health, that sort of stuff. The thing is DME is a kind of a cat and mouse game, because what it seems to be happening is that providers will create this new sort of DME, and there's less regulation in that than, let's say, medication. So this new DME will be allegedly created, and then it takes some time for insurance companies to catch up and understand what this is and to reprice it accordingly. And next thing you know, providers will either create a new thing. So for example, back years ago, cold compress was a big thing. That's sort of dying out now, and now we're seeing more and more lasers, such as onlux, cold laser therapy, that sort of stuff. So like I said, it's a cat and mouse game. And because of that, it's important for adjusters and attorneys to keep a running list of the DME that they've encountered, as well as the payments that different insurance companies have paid for those DME charges. Because again, reasonable, one of the ways to determine, but not dispositive, is the market rate. And when the marketplace controls a rate for DME, that can help, especially if there's a unified front by insurers. So it's important to have a running list and to keep these investigations going to determine what's reasonable. And as we'll get into now, what is customary. So as I said before, the problem with determining if the charge is customary is that it's literally where there's no insurance, and that's directly from the case law. So in the Spectrum case, they actually cited Munson Medical Center versus Auto Club Insurance Association. And the court said that an overcharge is determined by looking to the provider's customary charge in cases not involving insurance. And the court went on to elaborate that, in its words, where there is literally no insurance in the lay sense of the term, no Medicare, no Medicaid, no Blue Cross and Blue Shield of Michigan, and so forth. So again, it's important to have this running list. And when it comes down to determining what's reasonable and customary, there needs to be a unified front, because the reality is, even though the case law says that a plaintiff seeking payment of no-fault benefits bears the burden of proving both the reasonableness and the customariness of the provider's charges, what we see in reality is courts that tend to be more plaintiff-friendly, and it's almost like that burden shifts to the defendant to disprove the reasonableness or customariness of the provider's charges. So again, as I said, and as I keep saying, it's important to have a deep dive and a deep understanding of this DME that's being created, used, proposed, charged, and to have a unified front against this to help crack down on some of this overcharging. And those are all my talking points. I appreciate you having me, Amber.
And that's all we have for you guys today. As always, thank you for attending My PIP Monthly. Please feel free to reach out to us with any comments, questions, or concerns.